And now at last we are going to discuss the termination of the agency. That means how the agency comes to an end, how the agency is terminated. So first under the termination is by agreement between the parties. When there is an express agreement between both the parties, means between a principal and agent, then there would be the end of the agency. It would be a termination of agency. Second is by revocation of authority by the principal. If the principal has revocated the authority of the agent anytime before it is executed, that means it is a termination of agency. This revocation may be express or this revocation may be implied with the conduct of the principal. But the revocation by principal is subject to the following conditions. One condition is where the authority has been partly exercised, it cannot be revoked. That means if the agent has worked proportionately on a particular transaction, this cannot be revoked. Where the agency is for fixed time and the principal revokes the agency, he is liable to pay compensation to the agent. Before revocation, it is very important that reasonable notice must be given to the agent that principal is going to revocating the agency. Third way is by renunciation by the agent. Means if agent want to terminate it by tendering the resignation, by ceasing to discharge his duties, by mere abandonment of the services, or by setting up any adverse title against the principal, means if agent has done anything out of these four, the contract between principal and the agent of the agency will automatically terminate it. Next is by the completion of the business of agency. Once if the agency was being made, the contract of agency was done with some particular business, with some target of some particular business, as soon as the business is over, the agency would be over. Let's say if the agency was to sell the property, once the property is being sold, the agency would be terminated. And next is by death or insanity of the principal or agent. Means if any of the party of the contract of agency, whether it's a principal or it's a agent, is dead or gets insane, in both these cases it's not possible to sue the case, it's not possible to create the legal relationships now. So in absence of this, this would not remain a valid contract, and this would give rise to the termination of the agency. So this is the termination. Next point is by the lapse of the time. If the agency is for a particular time period, so that means after the lapse of that time period, agency will automatically terminate it. By the insolvency of the principal, let's suppose principal got insolvent. When the principal becomes insolvent, he cannot be sued. He is not he don't have the contractual capacity now. And according to section 10 of the Indian Contract Act 1872, an insolvent person cannot be a party to a contract, hence the agency would be terminated. By the destruction of the subject matter, once the subject matter of the agency is being destructed, agency would be automatically terminated. By subsequent even rendering the agency unlawful. Initially the contract of agency was a lawful contract, but subsequently with the passage of time, something happened which was out of control, and now due to that emergency, due to that mishappening, the contract has become unlawful. So in that case, it would be termination of agency. See the example, due to the declaration of war, when the principal and agent have become the enemies, between there is a war between two countries, and now after the war the principal and agent have become the aligned enemies. So in that case, agency would become unlawful and it would be terminated. Last is by dissolution of a company. Once the company is being dissoluted, the agency would be automatically terminated.